Court officer, sir. Court officer.
ಹೇಳಿ ಸರ್.
ಇದು ಕಲಬುರ್ಗಿ CH-2 ಅಲ್ವಾ?
ಹೌದ್ರಿ
ಓಕೆ, ಲಾರ್ಡ್ಶಿಪ್ ಹೆಸರು ಬೇರೆ ತೋರಿಸ್ತೈತೆ, ಅದಕ್ಕೆ ಕೇಳಿದೆ.
ಸರ್. ಅದು ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇರ್ತೈತೆ, 10:30 ಆನ್ ಮಾಡ್ತೀವಿ ಸರ್.
ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಸೆಕೆಂಡ್ ಸೆಟ್ ಸದ್ಯಕ್ಕೆ ಕಳಿಸಿದ್ವಿ ಅವ್ರು ಮಾಡಿಸ್ತಾರ ಇಲ್ಲ ಮತ್ತೆ ನಾವು ಹೇಳ್ಬೇಕಾಗ್ತದೆ ಡಿಕ್ಟೇಟಿಂಗ್ ಜಜ್ಮೆಂಟ್ ಅಂತ ಮತ್ತೆ ಅಲ್ಲಿ ಕಳಿಸಿ ವಾಪಸ್ ಗುಡ್ ಮಾರ್ನಿಂಗ್ ಏನು ಮಾಡಿ ಮ್ಯಾಮ್ ಮಾಡ್ತೀರಾ ಎಲ್ಲ ಚಲೋ ಬರ್ತದೆ ಪಾಲು ಹಾಕ್ತೀವಿ ಸ್ವಲ್ಪ ಪಾಲು ಅಲ್ಲ ತಡ್ರಿ
Monday.
We have to finish what we have. We have to finish. Our screens are full. Yes.
Where is adjournment?
One submission. I'm sorry to say this. Yesterday, as per the directions of your lordships, my lord, I informed the assistant commissioner not to hold the meeting. My lord, therefore, the assistant commissioner, she was on the way to Tengli village and near to the Tengli at school, my lord. Those people have, my lord, observed the vehicle. And she turned back, my lord, came back, and thereafter, my lord, they have not conducted the meeting. All the villagers locked the, my lord, panchayat office and
Members.
members ಬಹಳ ಜನ ಬಂದಿದ್ರು. Evening, my lord, at around 5:45, while I am going back on the main gate, they have stopped me and threatened me. Why you have phone called? Why you have stopped? The assistant commissioner is telling your name. I have told, no, court ಹೇಳಿದೆ, ಸಾಹೇಬ್ರು ಹೇಳಿದ ಮೇಲೆ ನಾವು ಹೇಳ್ಬೇಕಾಗುತ್ತೆ ಅಂದ. ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ತೋರ್ಸೋ ಮಾಡೋ, ಸಿಂಗುಲರ್ ಅಲ್ಲಿ ವಲ್ಗರ್ ಅಲ್ಲಿ ಈ ತರ ಎಲ್ಲ ಮಾತಾಡಿದ್ರೆ ದಿಸ್ ಇಸ್ ವಾಟ್ ಮಲಸ್ ಗೋಯಿಂಗ್ ಆನ್.
File an affidavit and place it. No,
Please.
file an affidavit.
Please, my lord.
Huh?
Please.
You file it along with the memo and place it.
Please, my lord.
If you require any kind of protection for some time, we can always instruct you. Let
No,
us.
that if such a situation arises, I request my lord. As of now, I have answered and they have went
But
back.
please file an affidavit.
I will file, madam. I will bring to the my lord.
And you mentioned
Yes,
that this has the effect of interfering with your functions,
yes, madam.
government advocate,
Please, madam.
being performed in court. You
Please.
mentioned that.
Please, madam.
Place the list of members also who have restrained you.
My lord,
Ascertain.
I can identify them, but I don't know them. They may be respondents in that matter.
That's okay. Try to name if you can identify.
Page number 5. 13 to 16.
My lord, serial number 15 on Monday or Tuesday on behalf of Kripasagar Patil.
Delist 15. Delist. Right? Relist the matter of
17th,
ಯಾವತ್ತು?
17th, 18th, any date, my lord.
17. 17. Inform the other side.
I have informed.
Page number 6, page number 17 to 22. Page number 7, 23 to 26. Page number 8, 27 to 29.
Serial number 17 on Monday.
Yes, 17.
17, my lord, Monday.
ಏನಾದ್ರು
Monday
ಅರ್ಜೆನ್ಸಿ
post.
ಇದೆಯಾ?
ಹಾ,
ಏನಾದ್ರು ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
senior KT.
ಆಯ್ತು, ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಹಾ, my lord.
ಏನಿದೆ?
ಅವ್ನಿಗೆ ಏಜ್ ಲಿಮಿಟ್ ಆಗ್ತಾ ಇದೆ ಅರವಿಂದ್.
ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರಾ, ಸೆಲೆಕ್ಷನ್ ಮ್ಯಾಟರಾ, ಏನಿದು?
ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್.
ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್. ಈ ಲಿಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ.
Non-compliance of office subject.
Serial number, sorry to submission,
Serial number 15, it may be taken up on 24th,
No, let us.
please.
Number 1, Veerappa.
Serial number 1, I appear for the petitioner, my lords. I beg to appear in video conference. My lordships, Annexure E is under challenge, which is the order passed by the KSAT dated 7/2/2025, wherein the petitioner's challenge to her premature retransfer order dated 12/9/2024 has been rejected on the ground that the cadre of second division assistant in the Department of Stamps and Registration is a district-wise cadre. My lords, page 133 is the impugned order, my lords. And if my lords peruses paragraph 6, internal page 6 of annexure E.
No, order is order of the tribunal.
Is at page annexure E, my lords.
Page
133, my lords. Page but in the entire order, nowhere those points have been considered. The tribunal does not hold that the cadre of SDA is a district-wise cadre, and in turn it justifies and rejects the retransfer order, premature retransfer order, holding that the department has tried to correct its own mistake. My lordships, annexure B is the order of this honorable court, my lordship, wherein this honorable court at paragraph number 13 had categorically held that cadre of SDA is not a district-wise cadre. May I pursue my lordships to annexure B, my lords, page 57.
Where is the order of transfer? First, you take us to the order of transfer.
Order of transfer is at annexure C, my lords. Annexure A3, page number 34, my lords. That was the first transfer order dated 15/7/2024. Annexure A7, which was challenged before KAT, is at page 36, dated 12/9/2024.
Kindly be slow. We are not as fast.
Sorry, my lords. I am extremely sorry, my lords.
Order of transfer.
Order of transfer which is impugned before KAT is at annexure A7, my lords. Page 36.
No, annexure A.
A7, my lords. Sorry, my lords. Page number 56, my lords. 56. Page 57, may I persuade my lords to page 57, my lords. ದಿನಾಂಕ 15/7/2024.
Page numbers don't tally. However, you tell us annexure A7 dated 12/9/24.
Indeed, my lords.
Serial number?
There is no serial number. After the entire list is over, there is a written paragraph. ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರ ಅಂತರ್ಜಿಲ್ಲೆ ವರ್ಗಾವಣೆ ಮಾಡಲು ಅವಕಾಶವಿಲ್ಲದೆ ಇರುವುದರಿಂದ ದಿನಾಂಕ 15/7/2024 ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೂರಲ್ಲಿ ಬೀದರ್ ಜಿಲ್ಲೆ ಉಪನೋಂದಣಾಧಿಕಾರಿ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರ ಹುದ್ದೆಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಶ್ರೀಮತಿ ಶಾಹಿನಾ ಬೇಗಂ ಇವರನ್ನು ಕಲಬುರಗಿ ಜಿಲ್ಲೆ ಉಪನೋಂದಣಾಧಿಕಾರಿ ಕಚೇರಿಯ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರ ಹುದ್ದೆ ಶ್ರೀಮತಿ ಶೋಭಾ ಇವರ ಜಾಗಕ್ಕೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿದ್ದು ರದ್ದುಪಡಿಸಿದ್ದು ಸದರಿ ನೌಕರರು ಈ ಹಿಂದೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಸ್ಥಳದಲ್ಲೇ ಮುಂದುವರಿಯಲು ಆದೇಶಿಸಿದೆ. So the order of 15/7 is cancelled by order of 12/9/2024, holding that the cadre of SDA is a district-wise cadre.
Just 1 minute. Let us go to the 15/7 order.
Indeed, my lord. 15/7 order is at page number 34, my lords. Annexure A3.
Don't go to the page number. Your page number doesn't tally.
Sorry, my lords. A3, my lords. A3, my lords. I am at serial number 29.
terms of annexure A3, you are at serial number
29, my lords, 29.
So from Bidar to Kalaburagi.
Kalaburagi.
Now that has been recalled.
That has been cancelled on the ground that cadre of SDA is a district-wise cadre, not a state-wise cadre, and inter-district transfer is not permissible according to the annexure A7. This issue was well for consideration before this honorable court as well as before the honorable KAT in annexure B, my lords.
Just 1 minute. We want to know whether there is any bar on transferring a second division assistant from Bidar to Kalaburagi.
There is no bar, my lords. There is no bar. May I persuade to annexure B, my lords, page 57.
Just 1 minute. We are on a different point. We are saying if they want to send you or they want to retain you, that is the employer's discretion. How is it of any relevance to you?
My lords, if it is a premature retransfer order that needs approval of the honorable chief minister, I have reported to my duty. I have reported to my duties, and the reason assigned is not at all justifiable, my lords, in view of the orders passed by this honorable court, which I had also placed on record before the KAT in WP number 200-673 of 20.
Just 1 minute. Just a minute. You had reported for duty.
Indeed, my lords.
So in pursuant to annexure A3 order is on
15/7/24.
Now you were shifted to Kalaburagi from Bidar.
Kalaburagi. Indeed, my lords.
You reported in Kalaburagi.
Indeed, my lords. 18/7/2024.
18/7/24. Now the order is passed on
12/9/2024. Within 2 months.
Yes, government.
I'll just take my lords to one more annexure, my lords, and I'll annexure B, my lords. A judgment of this honorable court, coordinate bench, in WP number 200-673 of 22.
Yes.
Internal page number 11, paragraph 13, my lords. Admittedly, may I read, my lords? Admittedly, the petitioner challenge to the transfer order of respondent number 3 at his place at Sub-Registrar Vijaypur is in application number was mainly on the ground that second division assistant in the Department of Stamp and Registration is a district-wise cadre, and that he was not given a posting in the said transfer order. The tribunal by order at annexure A8 rejected the said contention, dismissed the petition. Neither the petitioner nor respondent number challenge, holding that the post of the second division assistant in the Department of State was state-wise cadre. I had also placed this judgment for consideration before the KAT, my lords. Despite that, without any reasons on the points framed, 2 points framed, the tribunal has held that annexure A7 order of retransfer dated 12/9/2024 is valid, and I have been directed to implement that order. As such, I am seeking for an interim order, my lord, before this honorable court for stay of the order dated 12/9/2024 24, as I had the benefit of the interim order even before the CH-2. This judgment was also cited and it was placed in my application as Annexure A8.
They have not taken any permission, is it?
Well,
For the premature transfer, they have not taken any permission.
no permission is taken, my lords. No permission is taken.
You continue there as on date.
Indeed, my lords. I have not yet been relieved.
She's already been relieved and I am working in the post.
From when?
From the date of 12/9/2024.
Let us see. There is no chief minister's approval.
Indeed.
This is regard to,
Is there chief minister's approval?
no, not necessary, because this is not a state-wise cater, it was a district-wise cater,
That
which
will
is
see. That's a matter to be.
that is also answered by the KT. The specific point is framed at para 6 of the judgment.
Forget state-wise, district-wise. If you post an officer, nobody, the state government is not blind. They're aware of the law. They have posted from Bidar to Kalaburagi.
Yes.
Employee
Indeed.
gone and reported and worked for 50, how many days? For 2 months.
2 months, my lords.
2 months.
That
employees
illegality
worked.
itself is sought to be corrected by virtue of this impugned order.
Let us see. That we have to hear.
That is what the observation of
No,
the
we'll see,
honorable
we'll see.
KT. Now,
Transfer-
I am working at this place.
Maybe you have to go back.
I have not been shown any place now.
Let the state break its head over it. Let the state break its head over it. State is responsible
The
for the
judgment
mistake.
which is being
No,
referred to
you
by
have no vested right to interfere in this. You are only a consequential person posted in that place.
Manoj-
When the main order of transfer goes, is upheld, then you will have to go.
by virtue of interim order till this point of consideration,
How many days you have been working? How many days you have been working?
since past 2.5 months I am working there.
Not? No. There was a interim order in our operation during the operation
ಅದನ್ನು
of the
observe ಮಾಡಿದ್ದಾರೆ
tribunal order.
ಅದನ್ನು observe ಮಾಡಿದ್ದಾರೆ
No.
ಅದನ್ನು observe ಮಾಡಿದ್ದಾರೆ.
There was an interim council. There was an interim order in your favor in the before the KAT petitioner.
My lords, yes, there was an interim order in my favor, my lords. Before the KT, there was an interim. I had the benefit of an interim order, and I have continued to work at Kalaburagi even after 12/9/2024.
That order was order of status quo. I am working on under the very same
Then you
place.
have two people working.
Let this matter be had on
No.
Monday. I will show
Not in
when I have
transfer.
taken the charge and
Not in transfer.
this point of without considering this point, I
matters-
cannot be removed.
No. We can't have. Then you have two employees working with the two tables in one office. We can't accept your explanation.
This point, let this point may be considered because this honorable court has already considered this
Transfer
point and
matters-
passed a detailed order.
Transfer matters we are not. We do not intend to accept.
It's not a transfer in
That we
absolute
hear. That
transfer.
we
It
have
is
to decide, not at this stage.
I should not be disturbed. At least the government should say whether I am working or he is working.
You ask the government.
Who is working ಅಂತ ಅವರತ್ರ ಹೇಳಿ.
We'll direct the government.
Let appointing authority take a call.
For all these tests.
Let them say. Let
That
them-
was the mistake committed which they have rectified.
That we don't. That is a matter for action.
That is the also observation made by
That we'll
the tribunal.
decide. We'll decide.
Now, if I am disturbed from the place and then thereafter it is been considered, there is no point.
May
I
Anything
conditioning
done-
the matter.
anything done
I
would-
specify.
Anything done would be subject to the outcome of the petition. We'll clarify.
Now, where should I go is also
So ask the government. Both employees are at fault. That's for the government to decide. If the government has passed an order without realizing their mistake and now rectify it, they should have thought about the consequence. Let them sort it.
Now she is being shown a place.
No,
Where should she work? And she is being relieved from the place,
There's
pursuant to
an
the
interim
order.
order before the KT is what they're saying. Now that we
Interim
can't
order
sit and
of
adjust.
status quo. Status quo where I was already working.
No, who you have drawn salary?
Manoj,
Have you drawn salary for 2 months?
yes, Manoj, that is the reason I am.
Have you drawn salary for 2 months?
Produce the records on Monday.
1 minute. The petitioner, have you drawn salary for the 2 months?
No, my lords. Salary is not I have no salary is not disbursed, but I have signing the attendance. I have been appointed in Kalaburagi.
Where is the order, interim order of the KT? Let us have a look.
Interim order of KT is at annexure, my lords.
Status quo. Page number 78. Or this matter could be passed over. I'll produce the records.
No, no, let us, we are not interested in transfer matter. Simple as
No,
that.
the only pass over I am seeking,
No,
only to produce the
no, let
records.
us see. Interim order is there, I'll have a look at it.
It is an order of status quo. Page number 78.
See, the same order has that.
An order of
The state government, you will have to take a disciplinary inquiry if anybody have not reported for duty. That is your obligation.
noted.
You can't have two tables. One, two, let us see, you take your stand in writing. The counsel for the petitioner submit that the pursuant to annexure A3, the petitioner had reported for duty at Kalaburagi, where he was transferred. Further submitted that the rescinding of order of transfer as per annexure A7 has in effect resulted in premature transfer and displacement of the petitioner. Full stop. It submitted that no procedure of obtaining permission from the chief minister was obtained. It's further submitted that the petitioner had enjoyed benefit of order of status quo during the pendency of proceedings before the tribunal. Matter requires consideration. In the interregnum, the interim order before the KAT would continue in the present proceedings as well. Full stop. Next. In the interregnum, the government to hold a summary inquiry as to a person who is functioning and ensure that there cannot be two officers working at the same place.
I take notice
He
for
is directed to
1, 2.
accept notice for respondent 1 and 2.
Other side we directed to serve the
P.
copy.
Patil appears for R3, petitioner to serve papers on the government advocate as well as respondent R3. Sister. When do you want?
Next week, any-
Interview.
24th. And we will come down heavily in transfer matters. Wherever we find either the employee is playing shadow games of not reporting for duty, playing with KAT, High Court, Supreme Court, curative petition, they must work. Somebody must work, and they must put in their appearance. And you can't be a mute spectator.
I request on 21.
On 24th.
21 may.
ಏನು ಅರ್ಜೆನ್ಸಿ ಸ್ಟೇಟಸ್ ಕೋ ಇದೆ ನೀವೇ ಸ್ಟೇಟಸ್ ಕೋ ಎರಡು ಟೇಬಲ್ ಇದೆ ಅದರಲ್ಲಿ
24 or 20
your table is more firm than the other table.
ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಮಧ್ಯದಲ್ಲಿ
24 or 25.
24.
Number 2, Gaurish Kashampur.
Brief.
My lord, copy, sir, to the advocate who is appearing before the lower court. I'll file necessary memo, my lord. Kindly, it may be taken on Tuesday. It is covered judgment, pay and recovery, my lord.
relist on, put it.
Grateful.
Seat number 3, SV Deshmukh.
Yes,
My lord, for recalling the order dated 8/11/22, because it is a preemptive order. I could not.
comply
go-
ಮಾಡಿದ್ದೀರಾ?
Yes, my lord.
ಹಾ? Comply ಆಗಿದೆ?
No, I have to, after recalling it, I will complete me.
ಹೌದಾ? ಅದ್ರ ಮೇಲೆ objection ಇದೆ? Mean ಮೇಲೆ ಎಲ್ಲ comply ಆಗಿದೆ? ಇಲ್ಲ. We'll allow you to comply.
Yes, please.
Pending consideration of A2 of 25 and 1 of 25. Appellant is permitted to comply with the office of
19 it may be posted.
Huh?
Please, 19 it may be posted, please.
19.
Please.
Seat number 4, Siddharuda V. Pujari.
Kindly pass out. my lord.
Yes.
Serial number 4, kindly pass out.
In urgency ಇದೆಯಾ?
So, the already D matter.
Pass over.
Number 5, Liaquat Farid Ustad.
For the appellant, my lord.
Yes.
Appearing for the appellant, the
Yes.
office objection is with regard to furnishing of translated version of Kannada that may be dispensed with.
ಮುಂದೆನಾ? The office objection relating to furnishing of translated copy of our Kannada annexures is kept in abeyance for the present. Then notice must go.
Yes, my lord. In this, my lord, I am also seeking for interim order. The lord, the
After delay of 102 days.
2 days, my lord.
What have you challenged?
My lord, I am challenging the order of the learned single judge, wherein the learned single judge has dismissed the writ petition on the ground that since the matter was finalized in some civil proceedings, that is incorrect, my lord.
OS 59 of 2016 was dismissed.
Dismissed. That
Appeal is also dismissed.
dismissed. In that proceedings, we were not made party.
You are not a party.
Not a party, and the suit filed by the respondents was dismissed.
Put it. The writ was filed by you, is it?
Yes, yes, my lord. Yes,
It was filed by.
filed by Jagdevi.
What was the prayer in your writ?
My lord, to set aside the order passed by the deputy commissioner, wherein
Regarding revenue entry.
revenue entries.
Revenue entry was transferred in the name of.
The name of Subhash, respond number 3, who is no way concerned to the family of the petitioner.
No, that we'll see. Now the single judge says that finding is recorded in OS 59 of 16 and confirmed in appeal.
Yes, my lord.
That you are saying is a wrong observation.
Wrong.
Now 59 of 2016 is between.
My lord, Subhash and other parties, my lord. We are no way. Jagdevi, Shantaman, Mahadevi are not parties.
So this is not binding on you.
Not binding, and the suit is dismissed. So therefore,
Suit is.
dismissed.
But you are not a party.
Not a party.
How are you claiming rights?
Lord, we are claiming right. Your Lordship may kindly see the pedigree which I have produced.
No, correct. Now, what is the order of the AC and DC now?
AC has held that, my lord, since respondent number 3 is no way concerned to the properties of the petitioners,
Subhash.
Subhash. So entries in name is illegal.
in name of
AC.
Subhash and set it aside.
Set aside.
What happened before DC?
DC has set aside the order of the land tribunal, AC, my lord.
Ah.
On the ground that, on the ground of OS, which has
59.
59. That is totally illegal, my lord.
No, now,
Please,
before the order of the AC,
please, my lord.
entry was in whose name?
Respondent number 3, my lord, Subhash. In
Subhash. That was set aside by
set
order
aside.
of AC. And entry continued from order of AC till when?
That is now also the in Subhash name is there. Order, after order.
So correct. Will issue notice, let us see.
Status, please.
No,
at
correct.
least-
For status quo, you are saying as on date, it's in the name of Subhash, isn't it?
It's in
As on date.
yes, ma'am.
Then how will it help you? Will issue notice, will hear the main matter. You serve the other side. If it's only on the basis of observation of civil court, yes, we'll set it aside. So we have to hear the matter. Issue notice, emergent notice to the respondents. EGA accepts notice for respondent 1 and 2. The appellant is permitted to serve counsel to the private respondents on the counsel who appeared in the writ proceedings.
Please.
Other side be directed to serve the copies.
Copies to be served on AGA.
Or at least, my lord, subject to the result.
No, let us see. Let us see.
Please. Any can I
Petition illa, but roster change ಆಗುತ್ತೆ.
can I request for any date, my lord?
ಎಲ್ಲಾಗುತ್ತೆ ಬರಲಿ ಇದು. First week of March I'll put you.
Please,
This is the matter in the first week of March.
please. Macho.
Number 6, Chaitanya Kumar
What is
Chandra.
past pending? No, issue notice on IA as well as main.
My lord, a week time may be granted, my lord. I'll furnish correct address.
Huh?
Serial number 6.
Huh?
A week time may be granted, my lord.
The counsel for appellant submits that correct address would be
Yes,
furnished
my lord, correct.
within a week.
Yes.
The list week after next. Yes.
Number 7, Mahantesh Patil.
We list next week.
Number 8,
Contemptual date could you?
Yes, my lord, I'm appearing for the petition.
Ratna Yogi Bhatt.
Please, my lord, I'm appearing for the petitioners, my lords. Last occasion, my lords, lordship directed the government whether the lower cadre can be posted for the in the place of higher cadre, but despite that, my lord, twice they have not filed any explanation. Now the clause list disclosed that some have filed the memo on that is not served upon me.
You have a look at it. Have a look at it. We'll relist.
On Monday, my lords, it's urgency. Monday,
Tuesday.
please,
Tuesday.
please.
What
My lord, I have produced two orders. Yesterday, my lord, you filed in the counter. One is, my lord, the officer who is working, being a lower cadre in the higher cadre post was suspended. And thereafter, some other officer was transferred. Those two orders along with affidavit, it is filed yesterday.
let us
And insofar as the instructions with regard to the whether the lower quarter officer can work in the higher post, that is concerned, I have not received any information.
then you complete on that.
Once again, I inform, I'll get. ಮತ್ತೊಂದು ಪತ್ರ ಬರೆದು
That attitude of the respondent, my lord, is not correct. When the matter is seized before this court, my lord, regarding this question, they have given the answer like this, giving some other the person to posting in this place. It amounts to contempt, my lord.
Tuesday.
Please, my lord.
9, Kadlur Satyanarayana.
Kindly be passed over. Parties were asked to be present, my lord. Kindly be passed over.
First.
respondent.
Sanganagowda Biraja,
No objection, my lord. That application could be allowed. My lord, the beneficiary has come in appeal.
Who's the impleading?
Lord, one no,
Rival claimant or what is it?
Nooranda Swami. My lord, it's a strange case where, my lord, the beneficiary of the acquisition has come in appeal and they say that, my lord, I am not the claimant who has, my lord, obtained the order in reference court. They say that somebody else is the owner and therefore, my lord, they are not intending to pay. So, my lord, that party whom, my lord, the present appellants claim to be the owner was asked to be impleaded. Actually, my lord, that owner is, my lord, not coming, my lord.
No, that is of no relevance.
Hello, that was my case.
Beneficiary must pay to the state. The state. There ends the role of the beneficiary.
Yes.
State is then to pay it to the owner.
Yes.
They have to inquire into it. If there's a dispute, they have to refer.
Lord, that inquiry is conducted in my reference. The
30
court holds that, Lord.
30 reference, Tara. 30 reference.
It was an 18 reference. That objection was raised. In that objections are answered saying that, my lord, I am the owner. But still, my lord, they don't want to pay me because, my lord, they say that somebody else is the.
So why should they pay you? They should give it to the government. Government has to
pay. My lord, there is a decree, my lord. They don't want.
Have they deposited with the?
They have deposited part of the amount. They have obtained an interim order of stay. My lord, it's my lord languishing, my lord, for last 6 years. My lord. I had sought for, my lord, permission to withdraw.
Hello, who is the beneficiary now?
Lord, HESCOM, my lord, the appellant here. HESCOM, the appellant here. My lord, it's a electricity supply company.
What personal interest they have now? What personal interest? Who appears for HESCOM?
Sangan got a bit. Could we pass over, my lord? I'll get him.
No, but let us understand.
Yes.
Land was acquired by the government. Notifications by the government. Isn't it?
For the benefit of HESCOM.
For the benefit of HESCOM. Then you filed 18 reference for enhancement.
Enhancement. That is allowed.
Order operative portion of reference.
Page number, my lord, 20. It starts from 21. Internal page number 21 of the judgment, last paragraph.
So this is only insofar as enhancement.
Enhancement.
Correct. Then?
Lord, thereafter, Lord, this order is challenged by HESCOM. One of the grounds is that, my lord,
HESCOM was a party in the reference proceedings.
yes, they are, my lord, respondent number 2.
Respondent number 2. Now, whether appeal could be filed by the beneficiary.
Lord, they have, my lord, anyhow, my lord, there is a award in their favor. They can file an appeal.
And they are also party.
On what point? What was in adjudication? Only the rate.
Yes.
What was in adjudication? Only on the rate.
Yes.
Appeal is against that order.
Yes. They have questioned rate as well, Lord, and also, my lord, discount. Their main contention was that, my lord, the award was passed in the name of the present person who is sought to be impleaded.
That we'll see. But rate is also an issue. So we have to
yes, no, yes, my lord. I'm not disputing that, my lord. They cannot question the award. That fact, my lord, I cannot say that. They are entitled to question the award. Not on, my lord, the count of, my lord,
that
somebody
we agree.
else.
But then that point also will have to be.
Yes, my lord. Anyhow, my lord, 50% is, my lord, now in deposit, not the entire amount. The court ordered that, my lord, subject to deposit.
You want release of that?
Yes, I had sought for release of that. My application is pending, my lord.
You have filed your IA?
Yes, my lord.
Well, it's not.
It's filed on, my lord, 13/11/2019.
We'll have it put up and we'll hear the other side.
Pleasure. Yes.
Similar orders are passed in any of the other references?
No, it's a single matter. It's a acquisition for, establishment of substation.
Enhancement is from what to what? How much to how much?
2 lakh and odd per acre, my lord, is awarded.
6,000 to
2 lakh.
2
lakh 58,000 per acre is awarded. Not, my lord.
Award of the LAO?
LAO was, my lord, 1996 acquisition.
6,000. SLAO is 6,000 per acre.
6,000.
Also.
Okay, let us see. Government. office to put up IA for release of amount. It to have been filed by the
Respondent.
respondent. Release the matter. Did
Srinivas,
My lord, I appear for complainant in this case. My lord, I filed an application for revival of the contempt. My lord, on the ground that, my lord, the due amount by the government was 12 crore 65 lakhs 44,562, my lord. And my lord, while filing a memo, they admitted that they have paid 2 crores and they are entitled to pay another 2.95 crores. Even, my lord, they are not paying the undisputed amount of 2.94 crore, 2 crore 94 lakhs 55,405, which they have filed along with the memo. Now, my lord, the direction was to comply the representation and to pay the amount in due. Admitted amount is, my lord, according to them, admitted amount is by the BBA Commission, Kalaburagi Mahanagar Palika itself was more than 5 crore, my lord, 4 crore 99 lakhs 80,405,
no,
according to them.
Order? Where is the order closing the contempt?
My lord, I sought for revival. The contempt was closed on the submission of the government advocate, my lord. They made a they made a statement that they have made a proposal for payment.
Cause list ಅಲ್ಲಿ order dated 31/1, revival order dated 31.
Yes, my lord, it was 31/1, it was closed.
AGA just take.
My lord, other side will directly serve the copy of the revival application.
Just
Now
serve
I
a
will go
copy.
through and I'll file the
Serve a copy
application.
and the
Objections.
petitioner to serve complete set
I'll
of papers, including copy of IA 1 of 24 on AGA relist. Yes.
My lord, I'm sorry, my lord, I was unable to hear the date, my lord. May I just ask one more time, my lord?
serial number 20, date 24th, sir.
Much obliged, much obliged.
Yes.
My lordship, the petitioner is the wife and she has been placed expertly before the family court Kalaburagi, and the expertly decree of divorce has been granted, my lordship.
You were served, not served.
I have been served, my lordship, but hand summons has been served, and I have been told that because of some partition is there, and it is the thing is that husband and wife are residing together, and 38 years their marriage has been placed. The expert is at ink page number 27, my lordship.
No, any apprehension of him marry?
Yes, well,
Huh?
yes, she is searching.
He's
She has told that she is searching at this age.
He is searching or she is searching?
He is searching. The
Pending.
four children.
Four children. Pending for the consideration of IA 1 of 25. Taking note that the proceedings have culminated in an ex parte decree.
Yes, my lord.
Huh?
Yes, my lord.
There would be stay of the order of the trial court in MC 127 of 2024, dissolving the matrimonial relationship.
Yes, my lord.
And the respondent is not to contract any fresh marriage during the pendency of the present proceedings. Issue notice on IA 1 of 25 as well as main TCR to be summoned.
Obliged.
Number 30, Deepak P. Bharat.
Direction was there by this court, my lord, in petition.
Yes.
For exemption, my lord, the complainant complainants are a businessman. We are sought for market fee exemption certificate from the first respondent, my lord. That was not been considered.
Not considered.
That has not been.
So take out notice. Who has to consider?
First respondent,
That is
joint director, APMC, my lord.
to notice to respondent number 1.
Yes.
AGA is directed to accept notice for second respondent. Delist the matter on
Publish.
Serial number 14. Terama Basavaraj body.
For the appellant, Your Lordship. By furnishing wrong address, ex parte decree was obtained.
You want to have the look at TCR, we can pass over.
No, Your Lordship.
You have
Yes.
copies.
Yes, I have the copy, certified copy.
Yes, Ganesh Naik, what do you say?
My lord, is the already the notice was the served before the my lord is the family court, my lord, is the acknowledgement is there, my lord.
Correct. Which address?
My lord, is the address is the mentioned is the Sapna, he has per the petition where the mentioned, my lord.
The
Kamlapur and district Kalaburagi, my lord, is their village, my lord.
Now,
please, my lord.
the notice by RPAD.
Please, my lord.
Notice by RPAD was refused. RPAD refused. The case of the appellant is that she had filed a domestic
violence
showing a different address. So this refused has to go.
Case, my lord, she was the qualified lady, my lord, has already the completion of the she was the intentionally, my lord, is the avoiding to the appear before the family court, my lord.
Now just tell me one clarification.
Yes, Lord.
When you filed the petition in MC 2020.
Yes, by husband. MC was filed by husband.
Husband.
Yes. In the year 22, Your Lordship, DV was filed by the wife.
Just 1 minute. Now in the original MC,
yes,
the date given was Ashok Nagar, Block 3, Ramnath Sangh Samudaya Bhavan, Kamlapur. If you look at the cause title,
yes, sir.
You just go to the main petition.
Yes.
MC petition.
MC.
Even those has per the Aadhaar card, my lord, is the mentioning the same address.
MC petition.
Please.
Copy of the MC petition.
Yes, sir.
Lord, is the
now Ashok Nagar is the address.
Yes.
Now you made a submission, respondent.
Yes.
The lower court says you made a submission that she has left the house. That is recorded in the order sheet. On 12/4/22, the respondent has left the house. That's what you have stated. So the second address that you have given, for which notice is taken, the second notice,
yes, 11/7/2022.
If you have the order sheet of the trial,
please.
Yes. Now just go to 12/4/22 office notice.
Yes.
Left hand side. At 12/4/22.
Yes.
Left hand side.
Please.
For steps and the office note. Right hand side. Advocate for petitioner present submits. Respondent has left the house. Therefore, some time required to find address.
Please.
The second time notice that has gone thereafter is to the same address of Ashok.
Yes. That is on 11/7/22.
And that has come back refused. She says, as on the date of refusal date, she was staying at Balki.
Balki.
And she had filed a petition for under domestic one.
Please.
So it has to go.
But my lord, my submission, my lord, as per the Aadhaar card, my lord, is the mentioning the address, my lord, is the same Ashok Nagar, my lord, is the Kamla Nagar.
Change ಆಗಿರಲ್ಲ. No doubt Aadhaar card.
Aadhaar card
Your
on base,
lordship.
my lord, we are the made the my lord.
Very one submission, your lordship.
So maybe,
Please, my lord.
but then you have to rectify it, isn't it? Otherwise the record will continue to show old address.
Please.
Now she specifically says she has stayed, shifted to Balki.
Yes.
Now where is the DV petition? Along with additional document. You have filed along with additional document.
Additional document.
Additional document. Page number 1. That is at Kalaburagi, residing at Balaji Nagar, Bhalki.
Balki. Page?
1, your lordship, in the additional documents.
Additional document page?
DV Act is filed in the year of the 2022, my lord.
No, correct. Just to look at the date.
Please, my lord.
Let us check the date. 26, what is the date? 26 July 22, na?
Yes, your lordship. July 22.
July 22. You have shown the address as Balki.
Balki address, my lord. As per
That is a different taluka.
Yes, Kamlapur comes under Kalaburagi. Balki is of Bidar.
Now the notice of RPD was sent on
12/4/2022, my lord. There is the left the door.
12/10/22. 12/10/22. 12/10.
No, my lord, is the previous date is the 12/4/2022.
12/10.
12/10.
That is after this date.
Filing of the DV.
Huh?
After filing of the DV.
In the DV petition, have you stated shifting of residence?
Yes, your lordship. The new address. Moreover, your lordship, there is no any question of ambiguity because both the husband and wife are the native of the same village.
You go to page 6. Para 4, you have stated you have left the house.
Yes.
Page 6.
Petitioner is living at her parent house at Balki. We have taken it on record.
But we are not responsible if anything else has happened. We don't know if further marriage ends.
Your lordship.
Already, my lord, as per the
we have
information,
heard.
he has been already married to other lady. He is the my lord is the after the disposal of the KMC.
But you want your husband.
Yes,
Please.
your lordship. That may be remanded back to. Let them.
I'm asking. You want your husband?
Yes.
Any children from the wedlock?
No, your
But
lordship.
there's no issues.
ಆಯ್ತು ನಾವೇನ್ ಮಾಡಕ್ಕಾಗ you give the certified copies.
Yes.
Because you produce additional document only Xerox.
No, certified copies.
Correct. You have produced additional Xerox.
Yes.
So you file a memo and produce the original certified copies. The present appeal has been filed by the wife who was the respondent before the family court defending petition filed by the husband under section 13 within bracket 1 within bracket Roman 1-A of the Hindu Marriage Act, seeking dissolution of the matrimonial relationship on the ground of cruelty, na?
Yes, your lordship.
On the ground of cruelty.
Cruelty and harassment.
The decree of dissolution of marriage having been passed, same is in challenge by the appellant who was the respondent. Next, parties are referred to by the rank before the trial court for the purpose of convenience. The MC, the matrimonial case, came to be filed under section 13(1) so and so of the Hindu Marriage Act, seeking dissolution of the wedlock solemnized on 25/6/2018 between the parties. Full stop. It is the case of the petitioner that the respondent was frequently picking up quarrels with the petitioner, not cooperating with the performance of household obligations and duties, frequently going to her parents' house and staying there for months together, interfering with the respondent in his performance of official duties by frequent phone calls with long conversation during office hours, misbehaving with the petitioner, threatening filing of complaints against the petitioner, and other incidents amounting to acts of cruelty were grounds raised in the petition. It is noticed that the respondent was placed ex parte on the basis of notice sent to RPAD having been refused, and the trial court has proceeded to record a finding on points for consideration raised in the affirmative and has dissolved the matrimonial relationship. The point for consideration raised before the trial court is as follows: whether petitioner is entitled for decree of divorce on the ground of cruelty as alleged in the petition. Next, after holding the affirmative as regards such contention, the trial court has proceeded to dispose of the suit petition. Next, appeal is filed by the respondent wife and various contentions have been raised, and specifically asserting that no notice was served. Further submitted that though notice was stated to have been served in the sense that postal notice sent by RPAD was stated to have been refused, the said notice was issued to the petitioner, to the respondent, at the address mentioned in the petition, at the address mentioned in the petition at Ashok Nagar Block 3 near Ramnath Sangh Samudaya Bhavan, Kamlapur Taluk and Kalaburagi district. As on the date of alleged service of RPAD notice in the month of October 2022, the respondent had already shifted to the address shown in the cause title of the appeal memo at that also you have written the same. Yes. At the had shifted to Balki. ನೀವು appeal file ಮಾಡಿ change ಮಾಡಬೇಕು.
There is the changes after the appeal, my lord. The TV.
At Balki. It is specifically asserted that the respondent had left the house. Had left the house on 25/2/2020.
Yes, sir.
And such fact is evident from a perusal of the petition filed under section 12 of the DV Act, so and so Act, on 26/7/2022, wherein the address of the respondent was shown as page 1 of additional document, DV case cost title, which is the address at Balki. The appellant has filed certified copy of documents including the petition copy filed in the Domestic Violence Act, provisions of the Domestic Violence Act 2005, which was presented on 26/7/22, wherein the address of the respondent is shown as Balki. Accordingly, it is submitted that the fact that the appellant, the fact that the respondent was served at the address at Kamlapur was the wrong address to which notice was sent.
Yes.
And the order of and the postal shara refused cannot be taken to have been sufficient notice. Next, learned counsel for the respondent would submit that the documents of the respondent, including Aadhaar card, shows the name as mentioned in the cause title of the petition, that is petition filed under 13(1) 1A of Hindu Marriage Act, which would indicate that she is still residing at Ashok Nagar, block 3, and accordingly notice sent to the last known address should have been was sufficient. Next, it is to be noticed that since the order passed by the trial court was an ex parte order, and the main contention by counsel for the respondent is that if the court were to hold that notice was not sufficient, then the matter would have to be sent back to the trial court for fresh inquiry, as in the matrimonial proceeding, unless the assertions of the petitioner are rebutted by evidence let in with support of evidence of witnesses. The matter cannot be adjudicated by this court even otherwise. Heard both sides. Next, the point for consideration is as follows: whether the respondent has made out a case to hold that service of notice as sufficient requires to be set aside. Point number 2. Consequently, whether case is made out for remitting the matter for resumption of trial from the stage of appearance of respondent. Next, it must be noticed that the petition filed by the appellant husband before the trial court was under section 13(1) 1A of Hindu Marriage Act. The said petition was filed showing the address of the respondent wife as follows. cause title of petition in MC. It is clear on a perusal of the petition that the address of the wife was mentioned as care of Ashok Nagur Block 3, so and so. A perusal of the order sheet of the trial court proceedings would indicate that steps were taken at the first instance and matter was adjourned on various dates. On 12/4/2022, the trial court has made an entry in the order sheet as follows. Advocate for petitioner present and submits that the respondent has left the house. Therefore, sometimes bracket LSIC are required for find out the address of the respondent. Trace time for steps fall on 14/6/22. Subsequently, on 11/7/22, the counsel for the petitioner had again requested time to furnish the correct address. The entry in the order sheet on 11/7/22 is as follows, as it is. Next, clearly, the respondent was aware, the petitioner was aware that respondent had left home even as way back on 12/4/22 and had requested time to furnish correct address. Subsequently, it is noticed that PF and RPAD was furnished and as recorded in the order sheet of 28/9/2022 and on the next date, the office note records RPAD refused by respondent. Holding the service sufficient, the matter is proceeded with by noting the absence of the respondent. Full stop. The order of 29/11/2022 reads as follows. Adu Kannada allide. The trial court has held notice to be sufficient and proceeded. Full stop. The proceedings thereafter has gone further in the absence of the respondent and after recording the evidence of the petitioner. Trial court has passed an order on merits after recording a finding on the point for consideration in the affirmative, in effect holding that acts of cruelty were established. Next, perusal of the RPAD cover along with the TCR would indicate that notice was issued by RPAD at the address, as it is RPAD cover address, at the address of the respondent as follows. This would indicate that notice was issued to the address mentioned in the cause title of the MC petition, though counsel for the petitioner had undertaken to furnish the correct address. It appears that no correct address was furnished, despite specifically counsel for the petitioner undertaking to file details of correct address as the respondent had left home as observed in the order sheet above. It is further noticed that the RPAD was sent in the month of October 22. if the petitioner had undertaken for the court to furnish correct address as the respondent had left home, as is evidenced from the proceedings in the order sheet dated 12/4/22, clearly address furnished in the RPAD ought to have been different from that in the cause title of the petition, as admittedly the respondent had left home. Next, peruse the additional document produced by counsel for the respondent. They say of the respondent as noticed above that she had left the house as on May 2020 itself and was residing at Balaji Nagar, Balki Taluk, Bidar district. Is comes out from a perusal of the petition filed by the respondent under section 12 of the provisions of the Domestic Violence so and so Act. Perusal of the order sheet would indicate that the petition was filed on 26/7/22. Address shown in the cause title was Balki. The governments at para 4 of the petition also would indicate that the respondent had left the house of the petitioner, that is the matrimonial home, as on 25/2/2020. Certified copy of the petition is filed, and such government is found in para 4 of the petition. Next, in light of the above facts, it is clear that the RPAD notice with the endorsement refused appears to be cannot be relied upon to hold that notice was sufficient and the postal sharaf refused clearly is doubtful, as the respondent was in fact residing at Balki, and accordingly the notice to the Ashok Nagar address could not be taken note of. Solely on such ground, the finding of the court of service held sufficient requires to be set aside, as the presumption of notice issued to the correct address, as could be drawn by reliance on provisions of General Clauses Act, cannot be drawn, as the respondent has demonstrated that the respondent was staying at Balki as on the date of issuance of notice to the respondent in the month of October. Accordingly, once the order holding notice held sufficient is set aside, matter requires a retrial from the stage of appearance of the respondent. Next, the question of deciding on the petition and evidence on record by this court may not be appropriate, as in matrimonial disputes, essentially matters decided on the basis of averments of cruelty which needs to be established, also based on rebuttal evidence by the respondent to disprove the assertion of the petitioner. Accordingly, matter requires to be remitted back for reconsideration from the stage of appearance of the respondent. Accordingly, the judgment and decree of the trial court is set aside. Matter is remitted to the stage of appearance of the respondent. Parties to appear without fresh notice before the
family court.
Family court on
submission.
On 17th of March.
17th.
My lord,
17th
sir.
of March.
My lord, as per the respondent already he's being married, my lord.
But just one minute,
22.
just we make it clear that the evidence of the of the evidence of the petitioner on record would subsist, and the ಏನ್ ಬರ್ದಿದ್ದೀರಿ? ಏನ್ ಬರ್ದಿದ್ದೀರಿ? on record can be adopted by the petitioner by filing appropriate pleading, and if the petitioner were to adopt the evidence let in, same may be taken to be a part of the evidence upon continuation of the trial despite order of remand. Yes, full stop. After the appearance of the respondent, necessary pleadings by way of written statements would be filed within a period of, from then how many days you take?
A month, your lordship. From
1
the date
month of date of appearance, and matters to be proceeded with thereon as per procedure. Accordingly, appeal is disposed. Yes.
Lord, is the after the obtaining the my lord the divorce, my lord, the respondent is the prepare the marriage with the another one lady, my lord.
God will take care.
Obliged.
All contentions, needless to state, all contentions are kept.
Please.
Yes. Yes, yes.
Number 16, KM Gate.
There is statement of objections ready there, my lord. My
File
friend.
ಮಾಡಿ.
Same submission was made
ಹೌದು,
3 times
affidavit-
now, my friend, my lord.
Affidavit ಮಾಡಕ್ಕೆ ಆಫೀಸರ್
Very
ಬಂದಿಲ್ಲ.
old simple matter, 71, 72
It's
years
a
age.
financial
Petitioners, my lord.
Hello, what is the case?
Service
Financial
benefits, my lord,
implications.
equity was not given. An application was made before the honorable tribunal, my lord. Tribunal rejected the application only on the ground that there was about 400 days of delay in making application,
20
Not on
years.
merits.
not on the way.
What is
Just
the
that
benefit
was-
you are claiming?
Benefit, my lord, the petitioners herein, they were already
20
working
years
in the
delay.
local cadres. Thereafter, they were merged into Annexure A6.
So what is the benefit you are asking?
Benefit, my lord, equity in payment of the pensionary benefits along all the workers who are rendering along with services along with the present petitioners, my lord. The order came to be passed by the government.
So let him, we'll do one thing. Whatever is filing, let him file a memo along with the, we will take that on record because that will give your story.
Please, my lord.
Now, whatever,
Affidavit ಇಲ್ಲ.
correct. So
Please.
what, you file a memo
Please, my lord.
stating this is the proposed statement of objection.
Please.
However, in light of non-availability of official, this may be taken to be the stand of the
Government.
uh,
Please.
have it on Monday or Tuesday.
Please.
You file it, give him a copy, let him
Please,
have it.
please.
He list on Tuesday ಹಾಕದ Wednesday.
Tuesday.
Tuesday and Wednesday. ನಾನು
Wednesday.
ಇರಲ್ಲ, ಇವರು ಬಸರೆಡ್ಡಿ ಅವ್ರು
If
ಇರ್ತಾರೆ.
they don't file,
My lord.
you file it with a memo stating this is the stand, but due to unavailability of the official, this may be taken to be the stand of the government.
Please, my lord. Please. ಆಯ್ತು.
You give him a copy in advance.
ಆಯ್ತು.
Yes.
But on Tuesday? 19.
Mahesh Patil.
Relist. Effect of proceedings. AGA, some direction was passed. Some observation were made. Then instructions ತಗೊಬೇಕು ಅಂತಿದೆ. AGA to verify regarding effect of proceedings on 25/10/24 produced along with memo. Then ನೋಡಿ.
16/10 letter ಬರ್ದಿದ್ದೀನಿ ಸ್ವಾಮಿ, same day.
Wednesday. Relist on Wednesday. Find out.
ಆಯ್ತು.
Relist week after next. Yes. First one. Note.
Still number 4. Siddharuda Pujari.
The password.
Both parties are before the court. Last date of hearing, they were directed.
Any chance? Parties idhara?
We have either.
Let us sit. Let the other side is there. Let us see. Let us see. So 30 lakhs means 6 crores.
30 acres.
Okay, then what else you want?
My lord, there is a complex, commercial complex in survey number 29 and a house property.
Huh.
My lord, this property was gifted by father-in-law in favor of, my lord, a daughter-in-law, which is illegally cancelled by, my lord, the husband and got transferred in his name. There exists a complex, commercial complex.
No, correct. No, you can't take
It is getting, my lord, an income of around 2 lakhs, 2 to 2.5 lakhs per month as a rental income.
So you want to share in that?
My lord, our proposal is, my lord, that commercial complex which is being built on our property should be returned back.
Your property means?
Means this is a property which is gifted by, my lord, the father-in-law during his lifetime only.
But that has been cancelled.
Nobody has cancelled.
Nobody. Then why you said illegally cancelled something?
Mutation is illegally, my lord, cancelled and, my lord,
Okay,
transferred
so
in.
you want
That is also subject matter of
you
the
want the
suit.
commercial complex.
Yes.
What else you want?
One house property which is, my lord, for the purpose of residence, my lord, I am seeking, my lord, that is also in 29/1.
What is, he has got other properties apart from
The agriculture land, my lord, he has got other properties is, my lord, the agriculture land which is 30 acres.
his house you want or
Total 30 acres. Otherly 2/3 kehta ಇದೆ.
2/3.
ಹೌದು.
He has brothers or lone son?
He is the only son. And daughter was sent abroad for the purpose of education by availing loan. That also, my lord, requires to be repaid by, my lord, the wife.
Yes.
Monday post ಮಾಡಿ. Monday post ಮಾಡಿ sir. Seniors not.
Monday. 24th Monday. Yes.
May I make a submission?
Yes.
Serial number 19, my lord, it was present in the advance list, and at the beginning, my lord, I had argued one matter, and my lords had declared judgment, and this matter was posted on Monday, my lords. It was already there in the advance list, my lord. As I was hospitalized, I was not feeling well, my lord.
No, Mr. Patil. No, Mr. Patil. It will be in the list. It will be in the list. Let us see next week.
28 minutes will
I-
take. 28 criminal appeal. State appeal, small matter, millards. It is no stuff at all in the appeal, millards.
What is the offense?
It's a 307 and 366 and on 67 and 66 of IT Act. ma'am.
IT Act.
Nothing is there. All have turned hostile and
All have
nothing
turned.
is there.
Even 65B certificate is also not forthcoming. IO is not examined.
Yes.
IO, there is no faulty examination. IO himself is not.
Submitting on the
Next week.
code, that is there.
We'll take up next week.
Please. Next week.
Date could be Tuesday.
Reserved and ಕೊಟ್ರೆ ಬಂದೇ ಬಿಡ್ತು. Reserved and ತಗೊಂಡ್ರೆ ಬಂದೇ ಬಿಡ್ತು. मैं end of list कर ली थी. End of list कर दे रही. कर दे. यार ये लोग मत.
Madam, you call the list now from 19 in, from 19.
Number 19, Grecian party.
Serial number.
I appear for the appellant, my lord. Kindly it may be had on Monday, my lords. Same matter, my lord. ಅದು already ಇದಾಗಿದೆ.
First week of March on the date could be.
Temporal installment.
20. Second week ಅಲ್ಲಿ ಕೊಡಿ. 11. 21 also second week.
Number 22.
22, 19 and 2009. It's first week ಕೊಡಿ. 22 first week. 2009.
23, Syed Masla.
23. It will take up Monday. 17. Yes.
Number 24.
24 second week. 14/3.
Number 25.
25 8 years. This is also third week could be. Second or third. Second week could. 14 or 15 somewhere. Third week.
Number 26, Babu Rao. Mangani.
After 20th somewhere and March.
24.
24.
20, madam.
26 ಅಲ್ವಾ ನೀವು ಈಗ ಕಾಲ್ ಮಾಡಿದ್ದು ಅದು ಲಾಸ್ಟ್ ವೀಕ್ ಕೊಡಿ 24th.
Number 27.
27 just agent ಅಂತ ಹೇಳಿ notify after 2 weeks ಅಂತ date ಬೇಡ. 28 Monday. Monday dictation ಇದೆ ಅಲ್ವಾ Monday. Let it be in the list. ಎಲ್ಲಿದೆ?
Please, ma'am.
29 minutes. Today is the date given.
She has disappeared. He has disappeared. Hema Kulkarni has disappeared. Let it be on Monday.
Please, ma'am.
Then we'll see take.
29 minutes is a date given matter. 29 is a date given matter. Minute we are ready.
First week.
Resolution of.
First week on date good. Okay.
Some date in first.
Yes, Basaraj. 29/7/3.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗುತ್ತಾ?
ಆಗೋದಿಲ್ಲ, 2 ಸಲ ಚೇಂಬರ್ ಲಾರ್ಡ್ಶಿಪ್ ಇಲ್ಲ
ತಗೊಳ್ಳಿಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ, ನೋಡುವ ಮಾರ್ಚ್.
Court officer. Court officer.
ಗಿರೀಶ್ ಪಾಟೀಲ್ ಒಂದು 2 ಚೆನ್ನಾಗಿದೆ ಕೇಸು.
ಅದೇ ಅದು ಯಾವ ಡೇಟ್ ಹೋಗಿದೆ ಸರ್? ಫಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರು.
ಫಸ್ಟ್ ವೀಕ್ ಅಂದ್ರು ಮೇಡಮ್. ಅದು ಗಿರೀಶ್ ಪಾಟೀಲ್
ಸೀರಿಯಲ್ ನಂಬರ್ 19.
ಒಂದು ನಿಮಿಷ ಇರಿ ಸರ್. 5-3 ಹೋಗಿದೆ ನೋಡಿ.
ಓಕೆ.